Dear students, in our last module, we studied about the criminal laws and the civil laws. In this module, we will be learning about the powers of investigation and the procedure followed in investigation. After studying this module, you will be able to understand the term money laundering, no anti-money laundering laws in India, no punishment under Prevention of Money Laundering Act, no powers of investigating officers, and learn inspection of a crime scene. Now the introduction. What is a property crime? Crimes which are against property are known as property crimes. Property crime is a category of crime that includes crimes like theft, extortion, robbery, etc. It only involves the taking of money or property and may involve force or threat of force against a victim. The person committing this kind of crime seeks to do damage to or derive an unlawful benefit or interest from another's property. It is wrongful gain made out of crime. Next is Prevention of Money Laundering Act of 2002. What is money laundering? Money laundering is defined as the transformations of the proceeds of crime into illegitimate money or other assets. However, in a number of legal and regulatory systems, the term money laundering has become conflated with other forms of financial crime and sometimes used more generally to include misuse of financial system that involves things such as securities, digital currencies, credit cards and traditional currency, including terrorism financing, tax evasion and evading of international sanctions. The definition of money laundering in India is comprehensive enough to cover most of the instances of converting the black money into white by investing black money into certain corporations in the corporate world. Several sham companies, foreign investments, corporate mismanagement, insider trading and bribery are such examples which have linkage with money laundering. Now, what is black money? The term black money is not easy to define as it may have the characteristics of chameleon, changing its color. Black money has many terms like fraudulent money or dirty money, etc. Approximately around 1.945 billion Swiss francs, which is about 9,295 crore of Indian currency, has been alleged to have been laundered in by Indians in Swiss banks. And this is official information derived from the white paper of the Government of India in the year 2012. However, the real amount is yet unidentified and is suspected to be well above the estimated level. As per a study by United Nations UNODC, all criminal proceedings are likely to have amounted to some 3.6% of GDP or between 2.3 to 5.5% or around 2.1 trillion US dollars in 2009. Now is 2015's HSBC Leaks. In February 2015, Indian Express released the list of 1,195 Indians account holders and their balance for the year 2006 and 2007 in HSBC's Geneva branch. The list was obtained by French newspaper Le Monde and included the names of several prominent businessmen, diamond traders and politicians. The number of Indian HSBC clients is roughly double the 628 names that French authorities gave to the Indian government in 2011. Indian government said that it will probe into this matter. The balance against the 1195 names stood at rupees 25,420 crores. What are the various anti-money laundering laws in India? India has a specific money laundering law in the Prevention of Money Laundering Act of 2002, which has been amended by the government, and whoever commits this kind of crime can be punished for money laundering under this law. Now, who is liable for offences by companies? The Section 50 of Prevention of Money Laundering Act deals with the offences by companies. It provides legal action against a person committing a contravention of any of the provision of this act. Any person who at the time of contravention was committed, was left in charge or was responsible to the company shall be deemed to be guilty of the contravention and shall be liable to be proceeded against and punished under Prevention of Money Laundering Act. The only exception to such rule is that if such person proves that the contravention took place without his knowledge or that he exercised all due diligence to prevent such contravention but still he wasn't able to. Further, notwithstanding anything contained in subsection 1 of section 70 of PMLA where a contravention of any of the provisions of this act or of any rule, direction or order made there under has been committed by a company and it is proved that the contravention has taken place with the consent of or attributable to any neglect on the part of any director, manager, secretary or other officer of the company. Such director, manager, secretary or other officer shall also be deemed to be guilty of the contravention and shall be liable to proceeded against and punished accordingly. Now, what are the obligations of banking companies, financial institutions and intermediaries? Under section 12 of PMLA, all banking companies, financial institutions and intermediaries are required to maintain a record of all transactions they have done in a particular time interval in their bank, including information relating to transactions for a period of 5 years. This enables it to reconstruct individual transactions and furnish to the concerned authorities under PMLA all information relating to such transactions, whether attempted or executed, the nature and value of such transactions, verify the identity of its clients and the beneficial owner, if any, and maintain record of documents evidencing identity of its clients and beneficial owners as well as account, files and business correspondence relating to its clients. Now, what are the punishments under PMLA? Section 4 of Prevention of Money Laundering Act prescribes the punishment for money laundering as under: rigorous imprisonment for a term which shall not be less than 3 years but which may extend to 7 years or 10 years. The least punishment a person can get in such a crime is fine. In certain cases, the offences under Narcotic Drugs and Psychotropic Substances Act 1985 are punishable with rigorous imprisonment up to 10 years. The fine under PMLA is without any limit. Now, we will discuss about the process of making arrests. Making arrest in these kind of cases is a bit difficult as money laundering always takes place at a higher scale where the person committing the crime is well connected with the due city network of cops and other officials who have been already paid to avoid such a matter for the person in future. If arrests are made under section 19 of PMLA, the appropriate authority under the Act has the power to arrest any person provided that such authority on the basis of the material in his possession has reason to believe that such person has been guilty of any offence punishable under PMLA. After the arrest, the person arrested has to be informed about the grounds for his arrest. It is also required that the person so arrested shall within 24 hours be produced before the judicial magistrate or a metropolitan magistrate as the case may be having jurisdiction. Now, what are the various powers of investigating officers? The powers and duties of a police officer making an investigation are laid down in the sections 157 to 173 of Criminal Procedure Code. When it is necessary to summon any person to attend an investigation, the investigating officer may issue an order in writing in the prescribed form to such a person to attend investigation. It shall be the responsibility of the senior superintendent of police or any other officer vested with this task to supervise investigation of a crime or conduct of an inquiry to ensure that there is no inducement, threat or promise given to any person from whom inquiries are made or the information are elicited. No person should be unnecessarily called or detained under any circumstance. Doing so is against the rights of the person, and a lawsuit can be filed against the state in such a matter. Now, what is the language that is used for recording of statements? As far as possible, the first information report, that is the FIR, should be recorded in the language in which the complaint is made by the complainant. The statements of witnesses, as per the provisions of section 161 of Criminal Procedure Code, should also be recorded in the language in which they are made. FIR recorded may be in either Hindi or English or whichever language the person is comfortable in. It should be ensured that the statements so recorded do not contradict any evidence or record either in the form of documents or the statement of any other witnesses. The statement of the interpreter should also be recorded. In case any individual is not willing to append his or her signature to the statement so recorded, the fact may be recorded at the end of such statement. Sometimes people recording the FIR may want to remain unknown in the eyes of the accused. This can be arranged and the report can be submitted unsigned. Now, acquaintance with facts, rules, procedures, etc. The investigating officer may take assistance of any officer of another department in the investigation with the approval of the superintendent of police. While investigating cases pertaining to corruption, embezzlement, fraud, etc., or undertaking any inquiries relating to misconduct, the investigating or the inquiry officer must first acquaint himself with the facts, rules and regulations, and he should confirm the data he has about the case and make it flawless before starting the investigation. The investigating officer should ascertain all possible explanations likely to be offered in defense. Information may be obtained from the head of department or vigilance officers for furtherance of investigation. Their cooperation and help should be also secured in order to understand the procedures prevalent in a department. The help of the other departments like forensics and ballistics evaluation should be taken as well for further solving the case efficiently. Now, what are the clues to be followed up carefully? All available clues at the time of registration of an FIR or initiation of an inquiry or those becoming known during the course of investigation or conduct of inquiry should be carefully followed up. Inquiries should be made from everyone who is likely to be connected with the events which proceeded or accompanied or followed the crime or the subject matter of inquiry. Now, the inspection of the crime scene. The crime scene is the most important and useful place to look for evidence and clues relating to commission of crime and identity of the accused or the individual responsible for the event. This is more so especially in crimes such as murder, rape, dacoit, kidnapping, rioting and explosion, etc., because it exhibits first, information on the corpse and a positive identity on the victim. Second, information on the mode of crime or weapon used by criminals. Third, information to link a suspect with witness or victim. For example, the evidence like blood, hair, cloth, fiber, cosmetics, documents and other items from the victim may be transferred to the perpetrator. Such evidence helps in solving the case quickly. Fourth, information linking a person to the crime scene, such as different types of material like documents, fingerprints, blood, hair, fibers and soil, paint, etc. left by the criminal may be available at the scene of crime, which sometimes may provide one of the most vital clues about the whereabouts of the suspect. Now, photographing or videotaping of the scene of crime. As far as possible, the crime scene, the steps during the course of investigation such as pre-trap and post-trap proceedings, search proceedings should be photographed as well as videotaped so that they can be reviewed anytime and studied or viewed carefully later for clues or witnesses. Now, what is the technical assistance required in the investigation? There should be no delay in sending papers or exhibits for expert examination or in seeking expert technical opinion. The DNA samples recovered from the crime scene should be sent to forensic lab for evaluation so that further light can be shed on positive identity of victim. Investigations should not be kept in abeyance while waiting for records or experts' opinion or for the result of part inquiries by another officer. As far as practicable, inquiries in all possible leads may be pursued simultaneously, particularly of technical assistance that is available in CBI. In all investigations where foodstuffs or other articles of perishable or essential nature are involved, the investigating officer should not unnecessarily hold up the stocks but should take representative samples in the presence of independent witnesses for the purposes of evidence in the court and release the remaining stocks after observing necessary legal formalities. Now, we will start with the planning of investigation. The investigating officer should make analysis of the allegations in the FIR or inquiry registration report and focus on the main allegations for investigation or the main points for inquiry. The investigating officer, in consultation with the superintendent of police, would draw a list of points to be called plan of investigation containing the allegations to be proved, witnesses to be examined, documents to be seized and technical assistance or expert opinion to be obtained in support of, etc. without any delay. This plan may also incorporate details of part investigation to be referred to other branches, searches to be conducted, Interpol reference to be made, investigation to be conducted abroad, etc. The plan of investigation is not to be static but a dynamic one, which may be modified from time to time with the progress of investigation. The existing points may be revised and fresh points added as and when necessary. The superintendent of police shall review the same at the time of preparing the progress report or whenever the investigation is reviewed. In important cases, the DIG may also review the plan of investigation and issue necessary directions if any required in the said connection. Now, what are the measures to avoid delays in investigation? The following measures may be taken to prevent delay in the investigation of cases. As soon as the case is registered, searches are to be conducted. As soon as the searches are completed, a checklist should be prepared for all the authorities, including banks from whom documents are to be seized. Requisition for these documents should be issued within a week after registration of the case or after completion of searches as the case may be. Thereafter, reminders may be sent at regular intervals to the authorities concerned till the documents are recovered. However, in case the documents are not received in a reasonable time, necessary step may be taken to seize the same under the relevant provisions of law. If during the investigation further documents are considered essential, requisitions for such documents should also be issued immediately and officials need to be informed about the same. As soon as the documents are obtained, the branch SP should fix a target date for scrutiny and submission of the scrutiny report by the IO. Urgent investigations which may be required to be done even during the scrutiny of documents should also be completed by the IO in the meantime. As soon as the scrutiny of documents is over, the SP should ensure that witnesses are examined in a planned manner. The IO needs to take the statements of the complainant, trap witnesses, eyewitnesses in murder cases, etc., whose evidence is of an important nature and used to the case and should be recorded without any delay. Photocopies of the documents to be sent to the expert should be prepared and the original documents sent to the expert as early as possible. Material witnesses whose evidence is connected with the documents should be examined with reference to the original documents. The transmission of documents to the expert need not await the completion of the field investigation. While inspecting branches, the DIGs should specifically check if these instructions have been complied with by the branches. When the investigation of case is over, the SP should set reasonable deadlines for the IO to submit his FIR. In some cases, investigations are stayed by the court on writ petitions, etc. In every such case of stay, certified copy of the order should be applied for immediately and an appeal against the stay order be filed invariably. Action on this regard should be taken on top priority basis at every stage, as this is a matter which involves limitation. It should also be borne in mind that once the limitation passes, nothing can be done thereafter till the writ petition is disposed of. In this context, it should be borne in mind that in case All India Reporter 1985, Supreme Court 1668, the Supreme Court has discouraged the practice of courts in interfering with the investigation of cases. Now we will deal with a case study. Hassan Ali Khan was arrested by Enforcement Directorate and the Income Tax Department on the charges of stashing over 360 billion in foreign banks. The Enforcement Directorate lawyers said Khan had financed international arms dealer Adnan Khashoggi on several occasions. However, media sources claimed this case in becoming yet another perfect instance of how investigating agencies like Income Tax Department go soft on high profile offenders. Ali's premises were raided by ED as far back as 2007. According to several news reporters, the probe against him has proceeded at an extremely slow pace and seems to have hit a dead end. India Today claimed that it had verified a letter confirming the US dollars 8 billion in black money was in a Swiss bank UBS account, and the government of India too has verified with the UBS. The Swiss bank UBS has denied Indian media reports alleging that it maintained a business relationship with or had any assets or accounts for Hassan Ali Khan, accused in the US dollar of 8 billion black money case. Upon formal request by Indian and Swiss government authorities, the bank announced that the documentation supposedly corroborating such allegations were forged, and numerous media reports claiming US dollar 8 billion in stashed black money were false. India Today in a later article wrote, Hassan Ali Khan stands accused of massive tax evasion and stashing money in secret bank accounts abroad. But the problem is that the law enforcement agencies has precious little evidence to back their claims. For once, UBS Zurich had already denied having any dealings with Khan. So far, we have learnt all about the power of investigation in India. We also focused on the processes of investigation. different ways and methodologies to carry out the inspection of a crime scene were also taken into consideration. We also shed light on Money Laundering and Prevention of Money Laundering Act.